morning, everyone, and welcome to this new episode of The Future of Europe. Today is the topic of today is on the freedom of movement of third country nationals for the purpose of family reunification. This topic will be presented by Majcherczak, student in Master 1 of International and European Law here at the Université Catholique de Lille. Welcome, Arthur.
Thank you for having me.
So, let's start. What is the freedom of movement for workers?
So, within EU law, there are 4 freedom of movements that are enshrined in the treaties. We have the freedom of movement of goods, services, people, and capital. And the one that interests us today is the one of people and especially of workers. To explain this principle, when a worker of a member state wants to move to another one to work, they're free to do so. When under the provisions of Article 45 of the TFEU, which is the article that is specific to the free movement of workers, we understand that there's no condition for a worker to move to another member state. The second paragraph of this article states that it is prohibited to discriminate a national based on their nationality. The only limitations that can be made by the member states are on the basis of public policy, public security, or public health.
Okay, thank you for this clarification. You mentioned that these are EU law rules. So how come this freedom can apply to third country nationals also?
Well, in principle, the rules that are enshrined in the treaties are only applicable to EU citizens. However, Article 217 of the TFEU provides the possibility for the Union to conclude association agreements with third countries. In general, the aims of these agreements are to promote an economic cooperation between the two parties, namely the EU and the third country. The one that interests us today is the Ankara Agreement, which was signed in 1963 between back then the EEC and Turkey. This agreement seeks the free circulation of workers, their free establishment, and the free provision of services. The Council decision approving this agreement confers upon Turkish nationals the right to employment and residence in a member state.
Okay. Could you explain to us why would a non-EU national come to the EU as a worker?
Well, one of the motives that has been used by some workers to come to the EU is the purpose of family reunification. Indeed, we have a directive, the Family Reunification Directive, that establishes the legal framework under which non-EU citizens can join their family in the EU. This motive has served as a justification in the CJEU's case law, namely in the case Bozkurt, which is the most famous one, as it was one of the first ones. And in this case, the CJEU has analyzed the provisions on the freedom of movement of workers, of non-EU workers, in favor of the protection of their family members. The most recent case to date is the case X versus Unlandigenavnet from the 22nd of December 2022, in which the applicant used the purpose of family reunification to obtain her residence permit in Denmark. There was a preliminary ruling that was launched in this case to know if a Danish law was in accordance with the rules of the Ankara Agreement, mainly Articles 9 and 13, which respectively prohibit the discrimination on the basis of nationality and the prohibition of introducing new restrictive measures for Turkish workers. So to sum up a bit, the questions that were raised by the Danish courts, they wanted to know if introducing a law that imposes Turkish nationals to pass a Danish language test in order for them to obtain a residence permit, even when they apply for it for the purpose of family reunification, was a new restrictive measure in the sense of the prohibitions of the Ankara Agreement.
Okay, and what are the facts of this decision?
So we have a Turkish national that has been living in Denmark since 1979. He obtained his residence permit in 1985, and he's been since then studying courses in Danish and working also in Danish in different fields. He fulfilled all the conditions to obtain his residence permit, which is why he was issued one. We jumped later in time. He went back to Turkey in 2015 and got married to a Turkish national who then came with him to Denmark and asked for a residence permit for the purpose of family reunification. However, in comparison with her husband, she was denied her permit, and the Danish administration stated that the couple had not fulfilled all the legal criteria for them and for her to obtain her permit. Indeed, Denmark has introduced in 2012 a new law that imposes third country nationals to pass a language test, the Prøve i Dansk 1. And this law meant the previous one that imposed to pass the tougher version of the test. This was made so that the third country nationals could join the member state easier. Following the Danish administration argument, the passing of such test for the residing spouse is to ensure that the incoming one will be well integrated.
Okay, and has this situation occurred before in the EU?
Well, it has. The exact same situation occurred a few years ago in Germany, which led to the case Dogan. So in this case, Germany had introduced a law that imposed third country nationals to pass a German test in order for them to obtain a residence permit. In this case, the CJEU decided that this law was illegal as contrary to the provisions of the Ankara Agreement. However, on the point of the purpose of family reunification, in the Genk case, the court stated that family reunification is not a sufficient ground to obtain a residence permit.
Okay, and what was the outcome of the case you presented?
Well, the outcome was pretty much the same as the one of the German courts. The court gave reason to the applicants, so to the woman asking for her residence permit. It decided that to impose the passing of a language test is illegal as contrary to the provisions of the Ankara Agreement, namely on the prohibition of discrimination on the basis of nationality and on the prohibition of introducing new restrictive measures for third country nationals. The reasoning of the court followed those 2 points, which were the same as the Advocate General's opinion. So first, the court has ruled on the discrimination on the basis of nationality. Indeed, someone who was not born in a country cannot master the language as a native speaker in a short time. Thus, to impose such condition constitutes a discrimination on the basis of nationality. So to explain this a little bit further in details, the nationality basis does not concern only non-Danish national, but also non-EU nationals. Indeed, had the incoming spouse been from an EU member state, the question of issuing them a residence permit would not have been the same. Yeah. The second point that the court followed was on the language test, the Danish language test, and on its characterization or not as a new restrictive measure. So the court held that this test would lead the workers and their families to be forced to choose between a working life in Denmark and a family life in Turkey. The free movement of workers would be hindered here, and especially for non-EU citizens, as the Ankara Agreement would be disrespected. As such, the law regarding the obligation to pass the Prøve i Dansk 1 is contrary to the prohibition of imposing new restrictive measure in the sense of the standstill clause of Article 13 and represented a discrimination on the basis of nationality for Turkish workers. Additionally, the court stated in this case, and contrary to the Genk case, that family reunification is indeed a condition that the national authorities have to look at when it comes to issuing residence permits.
Okay, thank you. Very interesting. And in your opinion, how is it linked to the future of Europe?
Well, this case represents a positive step towards the enlargement of the EU and specifically a reduction of discrimination towards non-EU citizens. This case shows that the EU is positively applying the principle of freedom of movement of workers that exists and is enshrined in the treaties, but it applies it to non-EU citizens for the purpose of family reunification.
Thank you very much. That was it for the Future of Europe this episode, and thank you, Arthur, for coming and presenting the freedom of movement of third country nationals for the purpose of family reunification. Goodbye.